like to call the hearing to order this morning, and certainly want to welcome the panel members who were braving the weather to get here this morning. We appreciate that. Our ranking member, Mr. Rush, has been caught in traffic and is on his way, and when he gets here, I'm sure he'll want to give an opening statement as well. But today's hearing, we're going to be focusing on the Energy Consumers Relief Act of 2013, which was introduced by our colleague, Mr. Cassidy, who's a member of this committee. A couple days ago, we had a debate on the Keystone Pipeline. We had a hearing on the Keystone Pipeline, which I might say the American people in a recent Pew poll show that they support by a margin of 66% to 23%. And I think during that hearing, it really brought to the focus two different views of the way we should be proceeding in developing energy in America. One view, supported by many people in America, including some of our Democratic colleagues, view climate change as the most important issue facing mankind. Others, and they support more mandates and more regulations relating to energy, forcing energy costs upward. They support new energy taxes and a strong cap-and-trade system. Another vision, supported by many in this committee, is that we want a pathway to energy self-sufficiency, focused on maximizing abundant, affordable, and diverse energy resources, reducing emissions through technological development, economic competition, and market-based efficiencies. Now, I would say that in America, we don't have to take a backseat to anyone about being focused on the environment. Our CO2 emissions are the lowest that they've been in 20 years. EPA reports that total emissions of toxic air pollutants have decreased by approximately 42% between 1990 and 2005. EPA has said that since 1990, nationwide air quality has improved significantly for the 6 common air pollutants. Between 1980 and 2010, total emissions of the 6 principal air pollutants have dropped by 63%. Now, I don't know if any of you focused on this, but next year, the Dakota Prairie Refinery is going to open up in North Dakota. This is the first new refinery in America since 1976. Now, the reason that this has happened is that because of fracking on non-federal lands in the Bakken Formation, there's a bountiful production of this oil, and a refinery is absolutely necessary. Now, what many people don't know is that the tribes have submitted an application to build a refinery in North Dakota over 10 years ago, and it's taken 10 years to obtain this permit. And while everyone's excited about this refinery opening up, the problem is that it's been dramatically downsized because everyone is concerned about the new greenhouse gas rule that is expected to be coming out of EPA. So on one side, people are excited. On the other side, it's being artificially remaining a low-scale plant. Now, the great thing about this development in North Dakota and other parts of the country is that in North Dakota, the unemployment rate today is 3.2%, the lowest in the country. And since 2009, employment in North Dakota has increased by 60%. And so I think those two visions of America is what we're really talking about today. We have an opportunity to be energy efficient. We do not have to be dependent upon the Middle East or anyone else. As a matter of fact, we're the #1 oil-producing country in the world today, having passed Saudi Arabia in late 2012. Now, today we're going to take up a bill that would require EPA to be more transparent. There was a news release yesterday put out by the Society of Environmental Journalists that said that EPA is one of the most closed, opaque agencies in the federal government. And that's the view of many of us as well. So the legislation that Mr. Cassidy is introducing today simply requires a more thorough review of cost and the impact on jobs, energy prices, if the overall cost of the regulation will exceed $1 billion. So I think this is a very important piece of legislation, and we look forward to your testimony about it. And at this time, I'll recognize the gentleman from Illinois, Mr. Rush, for his opening statement.
I want to thank you, Mr. Chairman, and let me begin by commending you for agreeing at our last panel on Wednesday to hold a hearing, hopefully sometime in the very near future, dedicated solely for the purpose of hearing from scientific experts on the science of climate change. Mr. Chairman, as you know from 24 letters that Ranking Member Waxman and I have sent to you and Chairman Upton since May 2011 requesting hearings on this matter, climate change is an issue that the minority side takes very seriously, and we believe that hearing from actual scientists and climatologists rather than industry representatives will benefit and inform every member of this subcommittee. Mr. Chairman, we all understand that just because one might not like what the facts or the science is telling us does not mean that we can simply ignore science or facts or wish them away. Last year's records temperatures, record droughts, record wildfires, and record levels of flooding prove this point. Still, we are here holding yet another hearing on yet another Republican bill designed to gut the Clean Air Act and tie EPA's hands and prohibit the agency, this agency, from doing exactly what it was established to do, and that is to protect the public. Mr. Chairman, we know that the EPA does not simply propose regulations willy-nilly or just pull them out of thin air. In fact, every rule that EPA has proposed has been mandated by law, specifically to protect the public health by ensuring that all citizens have access to clean air, land, and water. My constituents do not always have the means and the wherewithal to hire expensive lobbyists to influence the debate in the Congress in order to enact policies favorable to their futures or their financial interests. So it is imperative that we allow the EPA to act as an impartial referee and ensure that the playing field is level for all Americans. This bill before us is flawed in so many ways, but one of its biggest deficiencies is that it will give the Secretary of Energy unprecedented authority to effectively veto public health regulations if the Secretary found that the rule will cause, and I quote, any significant adverse effects to the economy, end of quote. The analysis called for in this legislation is so skewed that even if the economic benefits of a rule dramatically outweigh any significant adverse effects to the economy, or rather to industry's profits, the rule will still be blocked. Mr. Chairman, I find that it's curious that my colleagues on the other side of the aisle are quick to point out that carbon emissions in the U.S. are down to mid-1990 levels, but refuse to acknowledge that the EPA regulations implemented under the Clean Air Act have played a key role in reducing harmful air pollutants by 60%, while at the same time our economy has grown over 200%. Mr. Chairman, my Republican colleagues can't have it both ways and attack the EPA for issuing regulations while at the same time point to the progress that we have made as a country, both environmentally and economically, due in large part to these very same EPA rules. The bill today is simply another sham that may serve as good messaging piece for the majority and its allies, but will never ever see the light of day in the Senate and will never ever be signed into law by President Obama. But if getting through today's hearing will help bring us a step closer to holding a real, meaningful, a real climate change hearing where we can really tackle the issues that most Americans truly care about, then, Mr. Chairman, I say let's begin the hearing. Thank you, and I yield back the balance of my time.
Thank you very much. This time recognize Mr. Upton, Chairman of the full committee, for 5 minutes.
Well, thank you, Mr. Chairman. You know, common sense dictates that we should fully understand the cost of new regs to jobs in the economy before they're implemented, especially the highest cost regs as the nation continues to endure high energy prices and unemployment. Maybe the EPA doesn't present a full economic analysis now because they know the public would not like what it hears, but transparency in regulatory costs is a reasonable expectation. And the Energy Consumers Relief Act will make sure that the EPA, in fact, provides it. Having worked in President Reagan's OMB, I have long been interested in the proper oversight of federal regs, and I cannot think of a set of regs more in need of additional oversight than EPA's energy-related rules. I want to commend Bill Cassidy for his Energy Consumers Relief Act, which is a common-sense solution that bolsters EPA transparency and puts American consumers first. For an agency that was never granted any energy policy setting authority, EPA nonetheless has taken charge of directing the nation's energy agenda. They're seeking to regulate where they've been unable to legislate, evidenced by EPA's avalanche of coal regs seeking to effectively regulate out of existence the use of abundant resource without any regard for electricity prices, reliability, or jobs. At a time when most Americans haven't seen gasoline under $3 a gallon in years, we now have a proposed Tier 3 gas rule that would put forward upward pressure on prices at the pump, creating a disproportionate hardship for the country's most vulnerable, those most likely not to be able to afford those higher prices. But gas prices aren't alone in being stubbornly high. With just 88,000 jobs created last month, it looks like 2013 is going to be yet another year with unemployment staying well above 7%. The Energy Consumers Relief Act gives the Department of Energy the lead role in conducting a multi-agency analysis of EPA's energy-related rules, estimated to cost at least $1 billion. $1 billion. No longer will the impacts of these measures on energy prices, jobs, or manufacturing competitiveness be a secondary consideration that is hidden from view. It is now more important than ever to weigh the consequences of EPA's actions. The U.S. is on a pathway to unprecedented energy self-sufficiency, a pathway that has seen technology and innovation in the energy sector drive new energy resource, abundance, diversity, and affordability, all for the benefit of consumers. Without the additional checks and balances that this bill provides, the pathway will remain threatened by an agency that sometimes fails to provide an adequate and complete picture of the sweeping cumulative impacts of its own regs. And I would yield to other members of the committee that might. Mr. Cassidy, I yield the balance of my time.
Thank you, Mr. Chairman. I am offering the bill this week, or next week, and actually the bill is actually about transparency. Dr. Rahm, I read your testimony, and it's all very nicely referenced, but there's nothing to prevent that from impacting or influencing or encouraging EPA to address the situation. All it is going to require transparency. Your article was so beautifully referenced peer-reviewed. I will note that EPA's work is not peer-reviewed. That's not me saying it. It's actually the National Academy of Science, which found on something regarding formaldehyde that the conclusions were not, that the draft assessment has not adequately supported its conclusions, et cetera, et cetera, et cetera. You would never accept EPA's document in a peer-reviewed journal. That said, EPA science can be specious. So this is about transparency. And the stakes are high. People are losing their jobs over specious science. Now, maybe the science is good, maybe the science is not. But I see nothing wrong with transparency and accountability. Why should the EPA be a dictator over our lives? Why shouldn't the EPA answer to somebody? Ultimately, Mr. Rush spoke about how folks back home don't have a high-powered lobbyist. I totally agree. So therefore, it is incumbent upon us to make sure that every bureaucracy has someone to whom they are accountable. In this case, it is the same administration. We would be saying that President Obama appointed somebody who was going to deep six his environmental agenda if he was the Department of Energy Secretary or if she was. I don't think that's very practical, very reasonable, or very likely. The fact is that everybody should be accountable. There are a credible number of jobs online here, and that the science at times has not been adequate. So therefore, I see nothing wrong with putting in transparency for those thousands, millions of Americans who cannot afford a lobbyist, but whose livelihood may be threatened by dictatorial powers which have no accountability. Thank you. I yield back.
Thank you. This time, I recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. When I woke up this morning, I noticed it had been raining. I was pretty sleepy. I didn't really want to come to work, and there was a cost to me because I had to do a lot of things to get ready. But I didn't realize the benefits. And the benefits is to sit here at a hearing to talk about a bill that doesn't make sense. So if I knew the full facts, I could have weighed the costs and benefits. If I just looked at the costs, that would be one way to make a decision, but you should look at the costs and benefits. Anyway, this bill says we're not going to look at the costs and the benefits. We're going to look at the costs. And if the costs are high, we'll forget about it. But that doesn't make sense because a lot of regulations weigh costs and benefits and say that the benefits outweigh the costs. During the 1990s, a lot of people looked at regulations and they said, oh, no, we got to have a cost-benefit analysis. Well, cost-benefit analysis is far from perfect. Important benefits can't always be reduced to a dollar figure. The estimates of compliance costs are frequently inflated, but cost-benefit analysis at least attempts to capture both sides of the equation. The problem with this bill is it says that when EPA does this cost-benefit analysis, they should then be accountable to the Department of Energy to make the decision. Well, why? Why should Department of Energy be superior to the Environmental Protection Agency? The benefits of most important rules dwarf the costs. Let me give you some examples. The benefits of the mercury and air toxics rules are between 4 and 9 times greater than the costs. EPA's tailpipe standards for reducing carbon pollution produce net benefits to society of up to $451 billion by saving car owners money at the gas pump. The benefits of these and other rules are huge. And faced with these facts, opponents of EPA now says we should simply ignore the benefits and consider only the costs. That's what the discussion draft before us requires. This is an extreme and nonsensical approach. Imagine applying this bill's premise to everyday decisions. Not my decision of whether to come this morning, but would somebody decide not to pay for a child's education for college, even though college opens doors to opportunity? If we look only at the price of medical care and not its benefits, would we forego medical care? Everyday Americans look at both the pros and cons in making even the smallest decision, but this bill would require decision makers in the federal government to look only at the downside of making critical investments to protect public health and the environment. This discussion draft is hopelessly flawed. It gives the Department of Energy a veto over EPA regulations. Is that giving one bureaucracy some accountability because it has to satisfy another bureaucracy which has another purpose than environmental protection when the agency in charge of environmental protection, after weighing costs and benefits, decides to go forward with a regulation. This is an unprecedented intrusion on the authority of the EPA. It is not common sense. It is not providing transparency. It is providing barriers to do something to protect public health and the environment if there's a cost that the industries don't like. And therefore, the industries can simply go and stop regulations. Now, let's see this bill more in detail. It requires the Department of Energy to conduct a skewed analysis of only the cost of EPA's rules without any consideration of the benefits. So if the Secretary of Energy determines that a rule will cause any, quote, significant adverse effects to the economy, that means a cost. EPA would be blocked from finalizing its rule after they went through a cost-benefit analysis, even if the economic benefits of the rule dramatically outweighed the costs. I have a further comments in my opening statement that I'd like to put in the record. But, Mr. Chairman, the American people want us to solve problems, not waste our time with partisan posturing, taking up nonsensical message bills, stand no chance of becoming law. This just deepens and justifies the cynicism of the American people. We have two problems that within our committee's jurisdiction that are crying out for attention: cybersecurity and climate change. And instead, we're wasting our time telling people regulations are no good if special interests don't like it, and they can convince the Department of Energy, which has no expertise on doing these regulations, to be able to veto them if there's any cost whatsoever. I think this is a real waste of time, and I wished I would have stayed in bed.
Thank you, Mr. Waxman. And that concludes the opening statement. So once again, I want to welcome the panel of witnesses today. We had invited representatives from EPA and DOE to attend, but they do not have witnesses here. But EPA did submit a testimony, a statement, and I'd ask unanimous consent that we introduce into the record the EPA statement. And at this time, I'd like to introduce members of the panel. We have Mr. Paul Sisio, who is the President of the Industrial Energy Consumers of America. We have Mr. Brendan Williams, who is Vice President of Advocacy for the American Fuel and Petrochemical Manufacturers. We have Dr. William Rahm, who is Professor of Medicine and Environmental Medicine at the New York University School of Medicine, and he's testifying today, I believe, on behalf of the American Thoracic Society. We have Ms. Rena Steinzer, who's a professor of law at the University of Maryland and is also president of the Center for Progressive Reform. We have Dr. Ann Smith, who's senior vice president of NERA Economic Consulting, and we have Mr. Scott Siegel, who is the director of the Electrical Reliability Coordinating Council. So we have some real experts with us today, and we look forward to your testimony upon this legislation. And Mr. Sisio, I'll recognize you first for an opening statement. Each one of you will be given 5 minutes, and there is a little box on the table that has green, yellow, and red means stop, so if you all would pay some attention to that, we'd appreciate it. Mr. Sisio, you're recognized for 5 minutes.
Thank you. Thank you, Chairman Whitfield, Ranking Member Rush, for the opportunity to testify before you and other subcommittee members. My name is Paul Sisio, and I'm President of the Industrial Energy Consumers of America. The IECA member companies have over $1.1 trillion in revenues. We have over 1,000 major manufacturing facilities across the country, and we employ over 1.4 million employees. IECA supports the draft bill entitled Energy Consumers Relief Act of 2013 because transparency of the cost of compliance is critically important to cost-effective regulation. Under this legislation, in the event that the review of costs finds that the EPA regulation would be harmful to the economy, we would hope that the EPA would reconsider the rule and seek alternative low-cost regulation. IEC has 3 points we'd like to share with you this morning. Point number 1, the EPA should not fear transparency of the economics of regulation. They should embrace it as part of their regulatory reform effort. And EPA should also embrace pursuit of a more accurate and less controversial method for calculating health benefits. Too much is at stake to not get these right. Both must be credible. The EPA must be mindful that the manufacturing companies have a choice as to where they build their facilities around the world. The U.S. and its policies are in competition with other countries for these investments and jobs. This means that U.S. regulations must compete as well. That is, to regulate in a manner that is cost-effective and implemented in a time horizon that are responsible to public health, but mindful of market realities. The most fundamental element is transparency of the cost of regulation. And in our view, the EPA scorecard is very poor. The EPA provided leadership decades ago in reducing emissions. They now need to lead again by addressing the cost and transparency issues. Congressman, this is a win-win. There are no losers. Point number 2. Besides the cost of EPA regulations placed directly on our own facilities, when the EPA promulgates rules and costs on, for example, the electric utility industry, it is us, consumers, that pay for that. When the EPA promulgates rules on the oil and the gas industry, it is us, the consumers, that pay for those. When the EPA chooses fuel mix strategies that give preference of one fuel over another, it's we consumers that pay for that. And there appears to be an insensitivity or a disconnect to this point as EPA proceeds to roll out a multiplicity of new regulations. Someone has to pay for these regulations, and that someone is the industrial sector and other U.S. consumers. As the only sector of the economy that competes with global competition, the pass-through of these costs to us is significant, and it's getting greater all the time, continually eroding at our ability to compete and create jobs. Point number 2. This is not 1970, when emissions were relatively high and significant action was needed to reduce any emissions. Emissions have dramatically been slashed since then, and that's the good news. The bad news is that now that emissions are small, the cost of the next increment of reduction is very expensive. So expensive that manufacturing companies could be forced to make decisions on whether to comply or shut down facilities and move production offshore. The reality is that manufacturers face a significant number of existing, new, or proposed EPA regulations all at the same time, with overlapping requirements and additive and compounding costs. This plethora of regulations has resulted in business investment uncertainty. Point 3. We encourage policymakers, all policymakers, to be mindful of another reality, that when companies spend capital on regulatory compliance, it consumes capital that would otherwise be used to create jobs, producing manufacturing products and exports, both of which are desperately needed to revive our weak economy and job creation. Thank you for considering our points.
Thank you, Mr. Ciccio, and Mr. Williams, you're recognized for 5 minutes.
Thank you, Chairman Whitfield, Ranking Member Rush, and members of the subcommittee for this opportunity to be here today. The Energy Consumers Relief Act is a common sense measure that will inject transparency and scientific rigor back into the regulatory process. While not stopping EPA's ability to regulate emissions, the legislation would inject a more rigorous review of the most costly regulations and foster a more robust public debate about the costs and benefits of the proposals. My written testimony details some of the nebulous, costly, and conflicting regulations that fuel and petrochemical manufacturers are facing. These regulations pose significant costs, often with questionable benefit, and ultimately impact consumers. The consumer impact of regulation is where I would like to focus my remarks today. Energy is truly the lifeblood of our economy. Affordable, abundant supplies of energy make modern life possible and have made America the most prosperous nation on earth. Abundant energy and a clean environment are not mutually exclusive. The air is cleaner today than it ever has been, and it's getting even cleaner. EPA notes that between 1990 and 2011, emissions of the 6 principal pollutants dropped 63%, while vehicle miles traveled increased 94%, and energy consumption increased 26% in that period. Today, emissions are so low that new requirements for incremental reductions become extremely costly. Given this reality, it is important to develop objective assessments on costs and energy supply impacts of additional regulations. Energy cost increases carry significant implications for consumers and our economy. Consider the following facts. Every penny increase in gasoline prices translates into a more than $1 billion increase in household energy spending. This is money that, as my colleague noted, consumers can spend elsewhere on other goods and services. In 2011, the trucking industry consumed more than 35 billion gallons of diesel fuel. A 1 cent per gallon increase would have translated into an additional $365 million annually for truckers. Every dime increase in gasoline or diesel prices sustained over a year cost domestic agriculture over $381 billion annually. In fact, 65% of farmers' costs are dedicated to fuel, electricity, fertilizer, and chemicals. Increased energy costs not only affect what consumers pay for transportation and for operating their businesses, but also manufactured goods. Petrochemicals are the basis for most consumer goods, and energy represents one of the largest costs for petrochemical manufacturers. To highlight the significance of petrochemicals for consumer products, consider the following. An average vehicle contains almost 600 pounds of petrochemical-derived plastics, composites, rubber, coating, and textile products. Home electronics, such as TVs, computers, and cell phones, contain up to 40% or more of plastics derived from petrochemicals. Nearly 14% of construction materials used in the U.S. are made from synthetic materials and derived from petrochemicals. Even renewable energy products, windmills, about 15% of them are derived from petrochemical products. These facts make it easy to see how energy cost increases have significant ripple effects throughout the economy. The potential for such ripple effects is why we need to ensure regulation takes a balanced approach that maximizes environmental protection without disproportionately raising consumer costs or sending manufacturing jobs overseas. The Energy Consumers Relief Act will help restore such balance. As previously stated, today's regulatory environment is characterized by costly and conflicting regulations with questionable benefit justifications. The legislation today establishes a thorough review of the most costly regulations by federal departments with expertise in energy and economic ramifications of regulations. Such a structure will serve as a check against the potential for EPA to overstate benefits while minimizing costs. Most importantly, by requiring a report to Congress, this legislation will increase transparency and give policymakers and consumers alike the opportunity to better understand the trade-offs between increased regulation and economic activity. Such measures will create a more balanced approach to environmental rulemaking that could significantly impact consumers and our economy. AFPM supports the Energy Consumer Relief Act and appreciates the opportunity to voice our opinion today, and I'll be happy to answer any questions at the appropriate time.
Thank you very much, Mr. Williams. Dr. Rahm, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Congressman,
You might want to turn your microphone on.
Congressman Whitfield and Congressman Rush. I'm Dr. Bill Rahm. I'm a professor of medicine and environmental medicine at New York University. I direct a division of pulmonary critical care and sleep medicine. I direct what's called the chest service at Bellevue Hospital. This is the nation's largest and oldest public hospital in the country. I've done this for the past 3 decades. I'm testifying today on behalf of the American Thoracic Society. It's a medical professional organization of 15,000 doctors dedicated to protecting lung health in the U.S. and around the world. I have 3 important messages I would like to convey to the committee. First, air pollution inflicts significant health risks to my patients. Second, reducing air pollution is good for public health and the economy. And third, Congress should let EPA do its job. As a pulmonary doctor, I spend my days treating patients who struggle to breathe. They have serious lung diseases like asthma, COPD, pneumonia, and a number of other conditions like sarcoidosis and IPF that most people have never heard of. Through a combination of medications, interventional procedures, and disease management, I work with my patients to help control their lung disease. However, there is one thing neither I nor my patients can control, that is the air they breathe, and it can be deadly. So let me share with you what I do on a daily basis. I'm an attending now at the University Hospital, and then after that I'm an attending at Bellevue, and then I always attend at Bellevue during the month of July. That's when the new interns come, that's when the ozone peaks, and that's when the PM accumulates. We have the largest emergency room in the city, and patients are admitted from there to my service, and I also oversee all the intensive care units. So I had a patient a while back during the summer. He was 53. He had both asthma and COPD. COPD is chronic obstructive pulmonary disease, and the chronic and the obstructive parts in that disease mean his lungs can't breathe well on a regular basis. Despite that, he went to the gym 4 to 5 times a week and works full-time as a computer programmer. One morning, he walked to the bus stop near his home to go and visit a friend. While waiting for his bus to arrive, he stood near the exhaust of an idling bus for approximately 5 minutes. Soon thereafter, he developed the acute onset of severe shortness of breath, and a bystander called the emergency medical services. In the emergency room, he was in extreme distress. He couldn't get air in or out of his lungs, and his blood pressure shot up to 200 over 139. He was emergently intubated and admitted to the intensive care unit. In the ICU, he required near-continuous bronchodilators, high-dose intravenous steroids, and neuromuscular blockade for management of a severe exacerbation of asthma and COPD. He remained intubated in the ICU for 9 days. He stayed in the hospital for 24 days. He was discharged to acute pulmonary rehabilitation to regain strength and conditioning. 8 weeks later, he was finally able to return to work. Absent the exposure to air pollution, my patient could have expected to live a fairly healthy life. Instead, air pollution nearly killed him. His brief exposure to diesel particulate and gases, combined with his underlying asthma COPD, led to this 9-day intensive care stay, 24-day hospital stay with all the associated costs, approximately about $413,000. So these are my costs. And there are 86,000 hospital admissions per year, 86,000 emergency room visits, 1.7 million asthma attacks, and on top of that, 160,000 deaths. So these are my costs, but on this ledger, they're called benefits, but they are real costs. And I would just as soon not incur these costs as a physician. We really should prevent all of these diseases. So when the air pollution is bad, the above scenarios are repeated across the U.S. My written testimony is full of the research articles that show air pollution causes a host of adverse health effects, including mortality and morbidity in the form of asthma attacks, heart attacks, COPD exacerbations, birth defects, low birth weight. Recent studies also link air pollution to loss of diabetes control, even in utero exposure leading to cancer in children, presented this week. The evidence is clear. Air pollution is bad for human health. The research is equally clear that reducing air pollution is good for human health and the economy. Recently, EPA stated the direct benefits of the 1990 Clean Air Act amendments and associated programs significantly exceed their direct costs. And even under the most conservative cost-benefit analysis that assumes no mortality benefit from ozone and particulate matter, the $137 billion in economic benefits of the 1990 Clean Air Act protections more than double the $65 billion in costs. If we include the mortality benefits, it's a 30-to-1 ratio. Lastly, I would note that in the past few years, the House of Representatives has frequently passed legislation that would block, weaken, or delay EPA's authority to improve our nation's air quality. Often the legislation is justified on avoiding the economic burden of compliance costs. Such thinking is short-sighted and fails to recognize the wealth of studies that show clean air standards actually improve our economy by preventing death and disease. Such thinking also fails to recognize that we as a society are already paying for air pollution indirectly through avoidable emergency room visits, hospital stays, missed work and school days, and death. Both our nation and our economy would be better served by paying the compliance costs up front and reaping the benefits of a healthier population. Thank you.
Thank you. Ms. Steinzer, you're recognized for 5 minutes.
Mr. Chairman, Ranking Member Rush, and members of the subcommittee, I appreciate the opportunity to testify today. My testimony makes 4 points. 1, the Energy Consumers Relief Act has no basis in law or fact and would enable some of the largest companies in the world to continue making record profits at the expense of public health and the environment. 2, the real danger we face is under-regulation. In fact, rampant deregulation of Wall Street is the reason why we've hurtled into the persistent recession that has impoverished millions. 3, regulation is vital to the quality of life we take for granted in America. Most of the rules targeted by this bill were not dreamed up in the basement of EPA by an administrator drunk on her own whiskey, but rather were required by the Clean Air Act amendments that were crafted by members of this committee. The beauty of the legislation from a corporate perspective is that it would gut the Clean Air Act, which remains overwhelmingly popular with the public, without ever mentioning its name. 4, Congress should focus on ways to reinvigorate the EPA rather than pursuing legislation that would kneecap the agency. The ECRA is nothing more and certainly nothing less than the latest attempt to shield some of the wealthiest and most heavily subsidized corporations in history from the relatively modest cost of preventing the chronic harm to people and the environment caused by toxic air pollution. It would force a shotgun wedding between EPA, the beat cop that polices the most intractable sources of pollution, and the Department of Energy, the government's booster for energy products nationwide. The inevitable outcome would be a marriage made in hell that stymies EPA's most important efforts to carry out its regulatory mission in deference to its salesperson spouse. The best way to think about ECRA is as a huge subsidy for companies that already pocket billions in government largesse. The energy companies that would reap this giant windfall include the big 5 oil companies, BP, Chevron, ConocoPhillips, ExxonMobil, and Shell, which raked in more than $119 billion in profits in 2012. Among the most profitable corporations, ExxonMobil finished at the top of the 2012 Fortune 500 list, bringing in profits of more than $41 billion. Chevron and ConocoPhillips finished 3rd and 4th on the list, bringing in annual profits of nearly $27 billion and over $12 billion, respectively. The legislation would relieve these companies from internalizing the high social costs of their pollution. This regulatory subsidy comes on top of the massive subsidies that highly profitable fossil fuel producers already receive. In 2012, the big 5 oil companies received more than $2.4 billion in various tax breaks from the federal government. The International Monetary Fund estimates that the fossil fuel industry receives more than $1.9 trillion in total global subsidies annually, an amount equal to 2.5% of the global gross domestic product. The rules in the legislation's crosshairs are among the most beneficial safeguards the U.S. regulatory system has ever produced. A 2011 report assessing the EPA's Clean Air Act regulations found that in 2010 these rules saved 164,000 adult lives and prevented 13 million days of work loss and 3.2 million days of school loss due to pollution-related illnesses such as asthma and cardiovascular disease, as Dr. Rahm explained so eloquently. Even when measured against the rubric of cost-benefit analysis, the EPA's regulations are revealed to be huge winners for society. The 2011 report on EPA's Clean Air Act regulations concluded that these safeguards would produce benefits worth $2 trillion annually by 2020, dwarfing the $65 billion in compliance costs. My written testimony gets into more specific criticisms of the bill. It also offers some suggested reforms for the EPA that would help the agency carry out its statutory mission. of protecting the people and the environment in a more effective and timely manner. Thank you. I'd be pleased to answer any questions you may have.
Thank you. Dr. Smith, you're recognized for 5 minutes.
Mr. Chairman and members of the subcommittee, thank you for your invitation to participate in this hearing. I'm Ann Smith, an economist and Senior Vice President of NERA Economic Consulting. My testimony is my own and does not represent any position of my company or its clients. If EPA and DOE are to be required to estimate employment impacts of energy-related regulations, it would be wise also to require that their estimates be made using analysis methods that are credible and suited to the scale of the regulation in question. For major energy-related regulations, an analysis that accounts for secondary or ripple effects through the full economy is the only type that can be expected to provide a balanced understanding of overall economic impacts. How has EPA been making its employment impacts estimates so far? In reviewing how EPA has been estimating employment impacts for its air regulations, I have identified several areas of concern, particularly with regard to its current practices. First, for air regulations released from 1997 through 2010, EPA rarely provided any employment impacts estimates. In the few cases that it did, EPA used methods that ranged from a single sector or partial approach to a full economy general equilibrium approach. I found no apparent pattern to explain when the full economy approach was used or was not used, but the full economy approach is clearly within EPA's toolkit. In 2011, EPA started to routinely provide employment impact estimates for its new regulations. However, these more recent estimates are not credible. They're being calculated in an inappropriately simplistic manner that uses a cookie-cutter multiplier. EPA's formula cannot even be called an analysis. This is what EPA is doing. EPA takes its estimate of the cost of complying with the regulation, states it in millions of $1987, and then, to estimate the number of affected jobs, just multiplies that cost by a single constant factor. That factor happens to be 1.55. So what does that mean? Well, you can do the math yourself. Because the multiplier is positive, this formula guarantees that EPA will estimate an increase in jobs for every one of its new regulations, no matter what sectors or types of regulation the regulation may affect, no matter what years the regulation may take effect in. In fact, the higher the cost of the regulation, the greater will be the job increase EPA projects for it. Furthermore, most of the regulations that EPA has applied this simplistic approach to are the very types of rules that are warranting a full economy approach. A full economy analysis is warranted for high-cost regulations that can affect prices of widely used commodities. Energy-related regulations over $1 billion would fall into this category. Also, the utility MATS rule, the Portland Cement MACT rule, the Cross-State Air Pollution Rule, and the Industrial Boiler MACT rule all fall into that category. Yet, all of those rules were instead run through EPA's simplistic job impacts multiplier, which predictably estimated that each one of them would increase jobs and that the most costly of them, the utility MATS rule, would increase jobs the most. I've done my own full economy analyses of several of those recent rules. I used NERA's New Era model, which is a full economy general equilibrium model, but I assumed EPA's own estimates of those rules' compliance costs. So I ran EPA's costs through a full economy analysis. And for each of those rules, the full economy analysis projected large negative employment impacts in direct contrast to the positive job increases EPA had reported. For example, the utility MATS rule, for the utility MATS rule, EPA had reported an increase in employment earnings equal to or equivalent to 8,000 jobs. But the full economy analysis of that rule projected a reduction equivalent to 70,000 jobs. Now, most of those negative employment impacts from the full economy analysis were in sectors that do not face any compliance obligations under the MATS rule. but they are sectors which purchase the regulated sector's higher cost product, electricity in this case. Partial analysis methods simply cannot identify these secondary or ripple effects. Simply put, because commodity price effects can cause a significant portion of a regulation's impacts, high-cost regulations should be analyzed with a full economy, general equilibrium approach. This is not a tall order. The past shows EPA already has the tools and capabilities to do it. Thank you.
Thank you, Dr. Smith. Mr. Siegel, you're recognized for 5 minutes.
Thank you, Mr. Chairman and members of the committee. Thanks for the opportunity to testify. My name is Scott Siegel. I'm a partner at the law firm of Bracewell Giuliani, and I also direct the Electric Reliability Coordinating Council, which includes some of America's top power producers that are working to ensure that consumers across the United States have access to reliable, affordable, and environmentally responsible power. Look, EPA has a tough job of balancing America's desire for environmental protection with its demand for affordable and reliable power. The agency has issued a number of environmental rules in the past 2 years and is working on others that at times seem inconsistent with this balance, and more of these types of rules are imminent. You've heard the names of all these rules, and we don't have time necessarily to get into every one of them, but Dr. Smith talked about the MATS rule, also the state or overturned, actually, cross-state rule, the changes to ambient air quality standards, water rules, the status of coal ash, regional haze rules, the list goes on and on. You know, if you do work for those that utilize coal, you almost get the impression that the agency doesn't like coal. It's funny how that works, since every rule I've named directly deals with coal. Worse yet than these rules is the capacity of the agency to engage in litigation with environmental organizations, settle that litigation prematurely on terms that are favorable to expansion of agency's power, and also the use of punitive enforcement strategies, and even direct opposition to the findings of state regulators who are themselves competent regulators who are in fact closer to the problems they seek to regulate. Taken together, these power sector rules impact about 780,000 megawatts of gas, oil, and oil-fired generation. Through year 2025, the most recent estimates show that 348 of the 1,300 coal-fired electric generating units are likely to close in 38 states, representing about 15% of the total coal fleet. The reasons for those closures, I think, are clear to all of us. The industry faces a combination of low natural gas prices and inflexible regulation. Merely losing 56 gigs, a mid-range scenario in line with what some industry has estimated, but also what the FERC, the Federal Energy Regulatory Commission, itself estimated, just to give you a sense of perspective, is the equivalent of wiping out all the power generation for the states of Florida and Mississippi. But coal still has an important role to play in America's energy future. As Tom Fanning at the Southern Company recently remarked, the U.S. still is the Saudi Arabia of coal, with 28% of coal's reserves. While the shale revolution is arguably the most transformative energy event in our time, recent reports have indicated that the most obvious projects for switching from coal to natural gas have already been undertaken. Many gas plants are running at or near capacity. They're running flat out, meaning that additional demand, assuming the economy ever recovers, additional demand may have to once again be met by reliable coal production. But as these rules increase the regulatory cost, those are passed on directly to consumers in the form of higher prices. Relying on fewer instead of more options puts us in danger of paying more for electricity, which affects the economy as a whole. You would think that the bill before you today is targeted only at the stock prices of energy companies, at least to hear some of its critics. That's not what triggers this analysis. It's the cost to consumers. And it should come as no surprise that higher electricity prices are destructive to our economy. Consider residential consumers, small businesses, hospitals, schools, farms, industrial operations all depend on reliable and affordable electric power. Higher prices disproportionately impact vulnerable individuals, including the poor, the elderly, and those on fixed incomes. 1/4 of Americans report having problems paying for several basic necessities. 23% have difficulty in paying their utilities. That's who is damaged when we don't fully take into account the consumer impact of higher electricity prices. By the way, we've heard discussion of higher gasoline prices, and I'd also point out that almost half of a refinery's operating cost, about 43% actually, is for energy, and few refineries have the capacity to co-generate appreciable amounts of electricity on their own, meaning higher electricity prices equals higher gasoline prices as well. Our schools, 99% of school superintendents found direct budget impacts as a result of increased energy costs associated with maintaining the building spaces. Worse yet, there is no alternative for a school superintendent other than to fire teachers to pay for more expensive energy. Healthcare. EPA's rules also adversely affect public health in three ways: by increasing the cost of medical care and treatment, by imposing real threats on human health by suppressing economic growth and the improved health that it brings, and by focusing on expensive rulemakings with little incremental benefit when those resources, if more sensibly deployed, could save many more lives. The bottom line, today's legislation is an important first step in the direction of addressing consumer impact and prices. It is not a gutting of the Clean Air Act. The power remains with the Environmental Protection Agency, not the DOE. The DOE makes an analysis. It is up to the EPA to decide whether to take that analysis seriously and address those energy consumer price endpoints. If they do so, the rule may proceed. So the power remains with the EPA to take consumer prices seriously. They should do that, and they should adopt this legislation. Thank you.
Well, Mr. Siegel, thank you, and thank all of you for your testimony. At this time, we'll open it up for questions, and I recognize myself for 5 minutes of questions. As I had indicated in my opening statement, the Society of Environmental Journalists recently issued a statement saying that EPA is one of the most closed, opaque agencies in the federal government. And I think all of us are very proud of the fact that the Clean Air Act has been unusually effective. EPA has done a good job of administering the Clean Air Act, and America does not have to take a backseat to any country in the world in being focused on a clean environment. And we all could recite statistics that reflect the success of the Clean Air Act. But I also think that we have an obligation and responsibility when we have an economy that is having great difficulty, of when we come out with new regulations that cost billions of dollars, that we also explore fully the impact that it has on the consumers and on society in general. All of us have a responsibility and a concern about people who suffer breathing problems, and that's why I think we can be very proud of the fact that we've made great progress. I know Dr. Burgess may talk about this a little later, but, you know, we're part of the Montreal Protocol because of the Clean Air Act, and because of the Montreal Protocol, Primatene Mist is not available over the counter anymore to people who have asthma. And as a result, their direct costs have increased dramatically because it's simply not available anymore. And Dr. Smith, I was really interested in your statement in which you said you did an analysis, and if I understood you, it appears that the more cost associated with an EPA regulation, according to their analysis, automatically there are going to be more jobs created. Is that what you said, or?
Yes, that's the formula EPA is applying right now.
And would you elaborate on that a little bit? I mean, that does not sound exactly correct, but.
Well, it's illogical, and that's why I say this is not an appropriate method in the first place. It's based on some earlier studies that looked at spending on labor worker payments to workers in industries in the 80s who were, for industries who were attempting to, who were reporting also their environmental spending. And the finding was that there was not across all four of those industries a significant change in the amount of spending on workers. But that did not find increased jobs. That just found that there was no change in the spending on workers in those four sectors in the 80s. Now, EPA is taking that summary statistic that says, well, the number was about zero. It was 1.55 on average. and just applying it to every new regulation that comes down the pipe, regardless of its relationship to the original study, most of which have no relationship to the original study.
So any regulation that has additional cost, according to EPA, will create jobs.
As long as they continue with this method of doing their analysis, which is, as I said, not really an analysis at all. It's just a multiplication that is guaranteed to provide positive jobs for more cost.
Right. Mr. Ciccio, you had, just a minute here. Well, I'm not going to ask you a question. I'm just going to make one other comment. I've been so upset about the stimulus money being directed to so many green energy projects, and I can't help but I just want to share that right across the border from my home county in Kentucky in the state of Tennessee, 2 years ago, a company called Hemlock Corporation announced that they were building a $1.2 billion plant that would employ 1,000 people and about 2,500 construction jobs to make polysilicon chips for the solar industry. And the state of Tennessee, there was a big press conference and everyone announced how this was the future for America, green energy, which we all support. Unfortunately, in January this year, after constructing this plant for 2 years at a cost of $1.2 billion, of which there was government money involved also, they announced that they were walking away from this plant. They had hired 300 employees to prepare it for opening, and they terminated all of those workers. They're shuttering the plant, and that, in my view, along with Solyndra and others, is an indication of how we in the government tried to mandate what was going to happen, and the marketplace was not ready for it. So I see my time has expired, and Mr. Rush, I recognize you for 5 minutes.
I want to thank you, Mr. Chairman. And Mr. Chairman, I due respect to the author of the bill, Mr. Cassidy of Louisiana, I must say that this bill defies common sense. Everybody in this room has probably sometime during the course of their lives written out pros and cons, listing in order to make important decisions. This bill will require the federal decision makers to consider just half of a list of pro and con lists when evaluating public health and environmental rules. The bill requires the Department of Energy to analyze all the potential negative effects of a proposed rule and determine whether the rule would have a significant adverse effect on the U.S. economy. Now, Ms. Stiser, under this bill, would DOE weigh both sides? Will they weigh the pros and the cons of a proposed rule?
Congressman, I think that they would focus primarily on the costs that are allegedly imposed by the regulation, and their analysis would come on top of an extensive analysis by EPA that is supervised by the Office of Information and Regulatory Affairs at the White House, that is redrafted, that is hundreds of pages long, scrutinized by economists. The Department of Energy already has an opportunity to comment on every rule that EPA prepares. And again, I would stress all of these rules are statutorily mandated. They don't come out of the right ear of the EPA administrator. They're all required by Congress.
So this bill requires a skewed analysis that completely ignores the benefits of the EPA's public health rules.
Yes.
As a matter of fact, have you, as you look at the bill, do you see the word benefit at all in the bill?
I do not. And bills like this act as if rules were sweeping the money into the center of the room and setting it on fire. They absolutely ignore the benefits to patients like Dr. Roms that he explained so well, the incredible economic costs, not just in medical expenses, but in days lost from work, staying home with a sick child, being unable to be productive is an enormous burden on society, and those are the benefits of trying to control pollution, would be to avoid all that harm.
As a matter of fact, the types of rules that this bill would target have tremendous benefits to public health, the environment, and often consumers. For example, EPA's greenhouse gas standards for vehicles are projected to save families more than $1.7 trillion in fuel costs and reduce America's dependence on oil by more than 2 million barrels per year beginning in 2025. That's just one example. How do the benefits of some of the EPA's other recent rules compare to the costs?
Well, as Congressman Waxman explained in his opening statement, the ratio between the costs and the benefits exceed the cost by several orders of magnitude in almost all of these rules. That's what makes it so ironic. These rules are a great bargain for the American people. And that's what makes it so ironic that they've come under this attack. They've been years in the making. They were initiated under the 1990 Clean Air Act amendments. We're now in 2013. These rules have been bounced around to court and back, to the agency, to the White House, to Congress, and finally, after all this time, they're beginning to get to the end of the runway and be ready to take off, and now we want further delay, further analysis, further number crunching, further hand-wringing, and it's just not what you intended. If Congress doesn't like these results, it should take up the Clean Air Act, but it doesn't want to do that because that would be very unpopular with the American people.
Thank you. Now yield back, Mr. Chairman.
This time I recognize the gentleman from Texas, Mr. Hall, for 5 minutes.
Thank you, Mr. Chairman. And I guess I'd like to start by not just thanking you, but thanking the folks as you have. And some of the proposed rules in the past few years, such as the cold ash rule and the cross-state air pollution rule, have been very detrimental to energy companies and thrust and jobs and consumers back in my district in Northeast Texas. I certainly admire Scott Siegel. I've known him and know the people he's associated with, Cersei Bracewell's old thrust there, and paired now with the former mayor of New York, do a good service for us. And that's why I want to direct my question to you. And I'm very pro-fossil fuels. I'm pro-energy, pro any source that might keep us from having to rely on countries that we really couldn't rely on if circumstances just changed just a little bit. But I want to talk about the compliance timeliness of the EPA's, and I'll talk about anything bad I can think of about EPA because I think they're the worst enemy of any nation's opportunity to get ahead and provide the energy that we have and that we need, and that we ought to be selling energy rather than buying energy. So I guess what I'd ask you is what your concern is about the compliance timelessness that I talked about for EPA's energy-related regulations. They're requiring to happen in just a few months, something that would have taken probably 4 or 5 years. and reconsidering it and then coming back with something just as ridiculous. That took us to the courts, and the courts there in courts from this Texas operation have recognized the wrong that and the lack of science that the EPA relied upon. And I thank Bill Cassidy for bringing this, and I agree with every word he said as we opened up here. But what I'm concerned about is, what do you think about the timelines and not providing enough time for utility to plan or implement these rules, and what effect is that going to have on electric reliability? Just in general, if you'd give that to us.
Mr. Hall, thanks for your kind words. I would say on the question of timelines, you do well to be very concerned about it. I mentioned briefly in my remarks about this sue and settle phenomenon, and unfortunately timelines are often not dictated, or at least not honored from a statutory perspective, but come to the fore for the EPA from settlements that they reach with environmental organizations, where they don't let other members of the regulated community into those settlement discussions. And so what ends up happening is a very, very sort of backwards-oriented and unrealistic time frame for implementation of the rules. We've heard a lot today about what a good bargain all these rules are. I'm kind of amused to hear that they're both a great bargain for industry, and at the same time, industry is the opponent that keeps us from having more of it. I mean, we should come. Industry folks should come to these hearings more often. They know about great investment opportunities in major EPA rulemakings. The fact of the matter is, despite the obvious costs outlined with respect to these rules, EPA always claims its regulations are net beneficial to society. That is like, it's not even worthy of discussion. In the case of the mercury and air toxics rule, for example, a rule that cost $10 billion, none of the benefits came from mercury. And if there were truth in advertising on rules, EPA would constantly be in front of the Federal Trade Commission explaining why they call their rules what they call them, and why they put in their analyses of benefits what they put in them. More than 90% of the benefits of this rule are co-benefits that come from reducing particulate matter, which, as we heard testimony, particulate matter is serious business. However, that 90% reduction comes from reducing particulate matter below the level that EPA has already said is highly protective of human health and the environment, with a substantial margin of safety for susceptible subpopulations of the very sort of person that Dr. Rahm was talking about. EPA inaccurately attributes the benefits to current rules, like the cross-state rule Mr. Hall was talking about, benefits that have been achieved by previous rules. It's like a poker game with one stack of chips, and they keep moving the chips from rule to rule to rule, claiming the same benefit. That's how Enron got into trouble. But
in closing, I know you agree with me that this bill is going to provide transparency and protects the consumer and protects jobs, and I'm very happy that we're looking at it today, and I thank you. I yield back. Our time's up.
At this time, I recognize the gentleman from California, Mr. McNerney, for 5 minutes.
Thank you, Mr. Chairman, and thank the witnesses for your thoughtful testimony this morning. It continually amazes me that our friends on the other side of the aisle think of the EPA as the devil, because before the EPA came along, we had the Love Canal, we had Cuyahoga River catching on fire, and look, China doesn't have an EPA, and would you rather live in Beijing and breathe that air? So, I mean, it produces a good service for our country. Now, it's important to have a balance. I understand that. But my concern with this bill is that it could indefinitely delay or block critical public health and environmental protections for an analysis of questionable value, in my opinion, by the EPA, by the DOE. Now, Mr. Williams, in your testimony this morning, you said that the bill would inject transparency and scientific rigor back into the regulatory process, but I'm skeptical of that claim. The bill requires the DOE to draft an inherently biased analysis that presents only the cost of the EPA rule, and that's already been brought out this morning, but does not address the benefits. The DOE is not really capable of that at this point. It would have to develop a new capability. Mrs. Stenzer, would you consider the analysis required by the bill to be transparent and rigorous?
I would not. Congressman. I think the analysis required by the bill would have the economists staring into a crystal ball in an effort to run the string of regulatory impact out into, it's almost like, you know, a butterfly flaps its wings in Rio de Janeiro and there might be an effect in Tuscaloosa. That's what's wrong with Dr. Smith's very superficial criticisms of what goes on in EPA analyses. You can't predict job impacts to the nth degree, and that's what people are insisting that the agency do. It already does extraordinarily rigorous analysis. There are a series of laws.
So you're going to describe some of the analysis that's required by the EPA already?
Yes. Very extensive analysis of both costs and benefits. And those analyses, again, I've need to get a life very clearly, but I spend many, many hours reading hundreds of pages filled with formulas. And we love the magical numbers. We think that they make these estimates precise and reliable, and in fact, the extensive analysis that's already done verges on guesstimates. As just one example, Dr. Rahm mentioned hospitalization for asthma. You know, in one of the cost benefits for the Clean Air Act, EPA awarded $330 for that event. And I'm sure Dr. Rahm would laugh at the idea that his patients go to the hospital and get the kind of treatment he was describing for $330. So all of these analyses understate the benefits, overstate the costs already. The agency has spent close to 30 years trying to get these rules out, and the pending legislation would delay us another few decades, which to the detriment of the public.
Thank you. Thank you. Mr. Segal, do you believe that a well-crafted regulations protecting air and water quality could result in innovation and job creation?
Yeah, I do. I absolutely do. In fact, the bill does not, you know, there's a rumor afoot in the land here that the bill does not account for benefits. No, the bill focuses very narrowly on these energy endpoints, but the bill also talks about shifts in employment. That's what you're, Congressman, that's what you're talking about, because when we have a regulation, we may well take the compliance cost money from that regulation, spend it, and then if I make a scrubber, for example, or I innovate a scrubber, that will create jobs. But the question is, the money that I took and spent on the scrubber and on the innovation related to the scrubber, if it were deployed in more productive mechanisms, what would the job multiplier be in that instance? And also... So
by more productive, you mean... You said would it be deployed in more productive measures?
Let me give you an example. Okay. Let's say I run a power company. All right, won't stretch credulity too much, but let's say I run a power company. If I don't spend the money on the scrubber, perhaps I can spend it on a way to improve the energy efficiency of my power plant. Presumably, if the EPA doesn't sue me under a new source review.
But it would have the same output if you increase efficiency.
Yes, it would also reduce, and that would not only reduce emissions, but it would reduce the cost of power. And then let's say my community, let's say a community in Northern California or something like that, would receive lower cost electricity, more small businesses, more energy-dependent businesses like florists and grocers and things like that could put on the extra job or two. That's real job creation, and that's the multiplier effect of lower cost electricity.
Well, I'd like to continue the discussion, but my time has run out, Mr. Chairman.
Yeah, gentleman's time has expired. This time I recognize the gentleman from Nebraska, Mr. Terry.
Thank you, Mr. Chairman. And this bill seemed rather simple and straightforward until the discussions occurred up here. And I want to ask the author, under current law right now, the EPA's the only thing they can do is look at the health benefits. That's the whole basis of it.
Yes, that's current law.
And are you striking that provision under this? I'm missing that language.
No, I'm not.
So the benefits under health are already written into law, and so what you're doing is saying that we need the other side of the cost-benefit analysis and determining the cost. Is that right?
A little transparency so that if someone loses their job because of the regulation, they actually understand what thought process went into it.
Yeah, so this is establishing a cost-benefit. The benefits are already written in there. Or mandated that be in there, and that's been part of our frustration here. And we mentioned the mercury rule. Their modeling showed tremendous benefit from reduction in mercury poisonings and injuries, but when you would subpoena medical records from a 60-mile radius around a coal-fired plant, you wouldn't find any mercury poisonings ever reported to the hospitals or physicians. I won't say ever. University of Maryland, I'm not too impressed right now. But I want to go in and talk about that. I think in a cost-benefit analysis you actually have to discuss, and I want to talk to Mr. Ciccio, because both the Republicans and the Democrats are working on job creation, and particularly in manufacturing. And we have what we're called a nation of builders, where we're bringing in manufacturers in all different industries, big, medium, and small, international, local. And it's interesting because all of them have said that energy prices are a key component. It's a major input cost. And right now in the United States we have an advantage, particularly with natural gas, to being affordable and reliable. So in our manufacturing plan, that's going to be there. The Democrats have what they call Make It in America, which part of their 4-point plan is affordable electricity, affordable energy. And as I understand, an increase of 1% in electric cost to a manufacturer in total could be $9 billion out of the manufacturing. Could you comment? Is that accurate?
Yes, Congressman. In fact, I can verify that 1 cent does equal a $9 billion cost on the manufacturing sector for our electricity.
And then define for us what that means to manufacturing.
Manufacturing competes global. As I said earlier in my testimony, we are the only sector that competes globally, and we have tough competition, particularly with the kind of products that we produce. Almost all manufacturers around the world can meet high-quality standards, and so the only thing that differentiates us from our global competitors is cost. And so your point about today, at this very moment, we have lower natural gas prices that is giving us a relative competitive advantage. But the other point associated with this bill is that policymakers and the EPA need to be mindful and remember that all of the costs of regulations on our producers of energy, whether it be electricity, natural gas, oil, what have you, all of those costs, when you're regulating those industries, get passed on to us, either directly or indirectly. And this weighs on this ability to compete.
Well, if we were successful in raising electric prices to the point where it's not economic to manufacture, do we just... will we be lowering the CO2 emissions globally?
No, of course not. It's the same way with other emissions as well. We simply shift the manufacturing facility offshore. Someone will produce that, and it'll be produced offshore, emitting, albeit
probably
greenhouse
more
gases or any other emission offshore rather than here.
So finding that line is important to actually reducing global emissions.
Well, absolutely. And our point of why we are here today is we're not saying don't regulate. We're not saying we don't want clean air. We're saying do it better, do it more cost effectively, and that's a win-win.
I'll interrupt just for my comment. I'll close comment. We've been on the eye of wanting to completely contaminate the entire universe, arguing a difference between 3 to 5 year implementation to make it more palatable and use technologies that don't even exist today. I yield back.
Gentleman's time has expired. This time I recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. The proponents of this bill argue it will enhance transparency and provide rigorous analysis of EPA rules. But I don't look at it that way. Mandating a one-sided analysis that ignores all of the benefits of EPA's public health rules is not going to inform anyone. The real effect of this bill is to indefinitely delay and potentially block crucial public health rules. Ms. Steinzort, this bill empowers the Department of Energy to effectively veto EPA rules. Isn't that right?
Yes, I agree with you.
Does the Department of Energy have the expertise to make the economic determinations this bill would require it to make?
The Department of Energy does not have that expertise, and one of the
I agree with you.
Yeah.
Now, under this bill, EPA cannot finalize a rule until the Department of Energy completes its analysis. Ms. Steinzer, does this bill establish a deadline for DOE to act?
No, it does not.
So are there reasons why DOE might not be able to complete its analysis in a timely way?
Lack of staff and expertise.
So important public health rules can be indefinitely delayed under this bill. Isn't that right?
Yes.
Dr. Rahm, what are the real-world impacts of indefinitely delaying EPA air pollution rules?
More hospitalizations.
You put your mic on.
More hospitalizations, more emergency room visits, increased mortality, enhanced morbidity, and this is nationwide, and it's over time, and it's actually not improving.
Justice delayed is justice denied.
Yes.
Regulations delayed could be help to people denied. Dr. Rahm, you're a pulmonologist. Over your career, I assume you've seen thousands of patients and had to review potential treatment options for a variety of conditions. How do you present treatment options to a patient? Do you review the benefits of a treatment as well as the potential risks?
Yes. When we treat asthma, for example, the standard treatment is a bronchodilator. Over time, these bronchodilators have become more selective, fewer side effects. Now we have inhalers that have particles instead of chlorofluorocarbons. We have highly selective inhalers, so we don't have to use things like Primatene Mist from decades ago. And we present these options to the patients. We now have inhaled steroid inhalers.
So you have a lot more advances. Members of this committee will remember a debate we had over Primatene Mist. From what I was hearing, the profession didn't think Primatene Mist was the best device to use. In fact, there were some downsides to it. Is that,
yes, there are.
I just want a yes or no on that, because
yes.
It's just an aside issue. Would you say to a medical professional who only presented the downsides of a potential life-saving treatment is doing an ethical job? This is a risk that you would take if you get this treatment for your health. This is the cost you may have to bear to get this treatment.
Yes, but we like to prevent asthma exacerbations by having patients not only take their treatments, but to have clean air.
So it's not ethical for a doctor to make a healthcare decision with a patient using the list of negatives without talking about the positives. Is that fair?
Correct. Yes.
When we go to a doctor or consult with our accountant or call our realtor, we want to hear the full story. We want to know the pros and cons before we make an important decision. This bill sets a different standard for critical public health and environmental standards to be determined under law by the Environmental Protection Agency. DOE could veto an EPA rule based on skewed analysis of those rules. That doesn't make sense from a public policy perspective, but it seems to me more likely when we mandate a skewed analysis of important EPA rules by requiring DOE to pretend that the rules provide absolutely no benefits, this bill really leads to indefinite delays or blocking of those rules based on an absurd analysis. This is a bill that we shouldn't be spending our time talking about, because it just doesn't make sense, even though we're being told it's common sense. This is not the way I learned common sense, and it's obviously geared to stopping important benefits from being provided to the American people. I thank you all for being here. I think you've all wasted your time just as we did, but you've given us perspectives on it, and I appreciate it.
This time I recognize the gentleman from Ohio, Mr. Latta, for 5 minutes.
Well, thank you very much, Mr. Chairman, and I want to thank the panel for being here. I really do think that the information that we're getting here is very, very valuable for this committee and for this Congress. In my district alone, I have about 60,000 manufacturing jobs, and I spend all my time when I get home on the road talking to those manufacturers. And when I'm out there, the number one issue I hear from them always, the top issue, are regulations coming from Washington and how it's hindering their businesses. And these are the folks out there, the job creators, the entrepreneurs that are out there making sure that their friends and neighbors have jobs that can put food on that table for those kids that they have and send them to school. And when we're talking about the number one regulator out there that affects folks in my district, the one group I always hear from all the time, that the number one agency is always the EPA. And there's not one group or business that I ever go out to see that would ever say that they're not for clean air and clean water. And so we want to make sure that we have those jobs in the future, because, again, with the 60,000 jobs that I have, the national manufacturers gave me a chart not too long ago that shows we have about 1.66 million manufacturing jobs on this committee alone, and that's what grows this economy. And I'd like to ask Dr. Smith, if I could start with you, and I know we've been having some of these questions going back and forth, but you testified that the effects of the EPA's major regulations can have regulatory impacts that ripple through the full economy. Could you elaborate on that?
Yes, so when a regulation is highly costly and the people in the sectors that have to comply with that regulation end up spending more money for the compliance, by and large, the cost ends up either being passed through to their customers in higher prices of the products, or there are international competitiveness effects where the affected sectors simply end up leaving the country and doing their business, their production overseas. Either way has trickle-down effects to the other sectors and the consumers in the economy. So if prices rise, for instance, for oil products or for electricity in this economy, there will be effects downstream for the consumers of that electricity, and that is where you start to see these economic impacts from a regulation inevitably spreading across into other sectors of the economy, and that's why the full economy analysis is appropriate in situations like this.
Thank you. And again, looking at my district in Ohio, that when we have so many manufacturers out there manufacturing jobs, we got to move that product, either bring that product going out, or we're going to have the material coming in. And the National Association of Manufacturers estimates that the cost of just 6 EPA rules affecting the energy sector could exceed $100 billion annually and threaten more than 2 million jobs. And Mr. Williams, if I could ask you, how are the refinery and petrochemical manufacturing sectors being impacted by those rules?
Sure. We're impacted in a number of ways. Obviously, we're impacted in the cost of producing the petroleum products, gasoline, diesel, jet fuel that runs this country, but also as energy consumers. So obviously, as Mr. Siegel earlier stated, when electricity, for a refinery, other than crude oil costs, the second largest cost is usually utility bills. So when something impacts electricity, it impacts us as an energy consumer. And then it impacts us, obviously, in the cost of producing fuels for the general public, fuels and petrochemicals for the general public. I had an example in my testimony of Tier 3 regulations. We reduced sulfur and gasoline 90% from 2004 to 2007, from 300 parts per million down to 30. Now EPA is looking to move from 30 down to 10. It's going to be a similar cost, and a lot of the stated benefit is minimal and even questionable.
If I can interrupt there, do you have any estimates of what that's going to cost the consumer out there with it going on from that Tier 2 to the Tier 3?
Well, if you just look at the production cost, an estimate we have is that it's a $10 billion upfront cost with about $2.4 billion annual operating costs. If you were going to break that down into cost in cents per gallon, it's somewhere in the 6 to 9 cents per gallon range.
Because I've seen some estimates, I believe, from the EPA that they're considering it's much, much lower. So you dispute that number?
Yeah, there are other studies out there that indicate they're around a penny a gallon. What those studies do is they actually look at the nation as one big refinery and try and apply reductions to basically either the nation as a whole or specific regions, when that's not how our industry works. Every single refinery is different and complex. The numbers I stated were from a model that actually assesses every single individual refinery and assesses costs via that methodology. So,
thank you very much. And Mr. Chairman, my time has expired and I yield back.
This time, recognize the gentleman from New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair. Dr. Rahm, you make a compelling case that people should limit their exposure to particulate matter and ozone. The legislation we're considering doesn't appear to repeal current standards, but it certainly prevents EPA from strengthening them. Are the current standards adequate, or can further benefits be achieved?
That's a very good question. The standards for ozone have been lowered by President Bush's EPA from 84 to 75. And we've recently looked at what would happen if we met the 75 ppm standard. There would be about 2,000 deaths averted across the country, heavily in the eastern third of the country. We've also looked at the proposed 70 ppm ozone standard, and it would avert about 4,000 deaths if we lowered it to 70. So the standard now of 75 that we're not even meeting doesn't protect health, and going to the lower standard would give us a greater benefit. For PM 2.5, we're at 35 for a daily, and we've been at a 15 microgram per meter cubed annual. That's recently been proposed to go down to 12. If you look at the mortality from PM 2.5, there are mortality and morbidity effects at this proposed standard, and some of the studies are now showing even effects lower than this standard. Of concern is lung cancer. There's recently been a study of over 100,000 people who are never smokers looking at lung cancer. There are 1,000 lung cancers in this cohort, and the lung cancer increase started at 8 and going up, and we're now just trying to reach a 12 microgram standard. So to try to derive health benefits with these standards, we're discovering health effects at or even below these proposed standards. So if we're going to protect and particularly susceptible populations, we need to get a protective factor in there.
And my understanding is that these air pollutants, especially ozone and fine particulate matter, can travel significant distances from their sources. So is this a problem only for people who live in our urban cores, or should there be a concern about suburban areas and rural areas that are impacted by these same pollutants?
Yes, there's a considerable transport of particles. However, there are what we would call hot spots, and what we've recently observed is that highways, or where there's heavy traffic, is a hot spot. So living near a road will increase your risk for developing asthma or having a mortality effect. And roads are across rural counties as well as urban counties. So air particulates have a large distance that they travel, particularly from coal-fired power plants, so that to control these, such ideas and concepts as the interstate rule was promulgated. It's difficult to develop these rules because they're always challenged in court. But the eastern third of the country, and particularly the coastal regions of California, have both ozone and PM 2.5 exposures that don't meet the standards, and it's a challenge to develop public health policies to meet the standards. We're getting there.
Thank you. Thank you, Dr. Rahm. And Dr. Steinzler, you have a table in your testimony listing a number of EPA rules that apply to the energy sector. They all appear to be rules that would be issued under the Clean Air Act. As you point out in your testimony, energy touches many factors in our society. The oil and gas industry already has exemptions from a number of our environmental laws, including the Safe Drinking Water Act, the Clean Water Act, the Clean Air Act, for gas production with hydrofracking, for example. Are there rules issued under other statutes that would also be subject to this law?
Rules issued under the Safe Drinking Water Act, the Clean Water Act, yes.
And other statutes, though, that would be affected by this law?
Yes, potentially, because the legislation says any regulation that costs $1 billion, but it doesn't give a time period for that. So if a regulation cost $100 million a year, it would be subject, any regulation under any law that could remotely affect energy producers would be covered by this legislation, even if the costs were substantially less than $1 billion, because we continue to multiply into the future.
Thank you. My time has expired, so with that, Mr. Chair, I'll yield back.
The gentleman's time has expired. At this time, recognize the gentleman from Louisiana, Mr. Cassidy, for 5 minutes.
Hey, thank you. Dr. Rahm, I'm also a doctor. I'm also an academic, and so I kind of know the field from which you come. Here is the National Academy of Sciences discussion of something that EPA put out. In roughly a 1,000-page draft reviewed by the present committee, little beyond a brief introductory chapter could be found on the methods for conducting the assessment. The draft was not prepared in a consistent fashion. It lacks clear links to an underlying conceptual framework, and it does not contain sufficient documentation on methods and criteria for identifying evidence. I could go on. Would that get published in a peer-reviewed journal for which you were the editor? Yes or no?
Probably not.
Yeah, probably not.
The National Academy of Sciences has looked at a number of...
If I may, I have limited time. Probably not. And yet, this was a draft that was going to incredibly impact the economics of certain industries. Next, you mentioned how there is an impact of PM25. By the way, this bill is not about that. It is about transparency so that there can be an economic effect. I think I know, although you're a pulmonologist and I'm a gastroenterologist, so I go here a little bit of fearing. Don't we know that socioeconomic status actually affects the incidence of lung cancer as well?
Yes.
So if we were able to say, if there's in this transparent process, that there is going to be a cost of blue-collar jobs, folks are going to lose their jobs, their families will be less well off, et cetera, wouldn't it be fair to say that that could potentially also have an impact upon the future prevalence of lung cancer among that population?
Well, the effects of tobacco and
yes or no? I mean, just because we know that economics has an impact, and we know that
much
people
larger than SES or socioeconomic status.
That's still a factor. So when Mr. Waxman spoke about how we want to speak about the not just the cost, but also the benefits. But if you're an oncologist, you not only want to talk about the potential upside, but also the potential downside. I can say that confidently. We all should do that ethically. So if we have a law which purports to give all this great health benefit, but we don't go into the fact that it could cost a blue-collar worker her job, we're not really talking about the downside, are we? Mr. Ciccio, I'm struck that in our current economic environment, our major challenge is creating jobs for blue-collar workers who have traditionally been employed in manufacturing, construction, and mining. You speak about energy-intensive enterprises moving back to the United States, recreating blue-collar prosperity, which we seem to have almost ceded to other countries. Is it fair to say that when natural gas went to $13 per MCF, there was a negative impact upon blue-collar prosperity?
When prices of natural gas rose, starting from about 2000 to 2008 to the point that you mentioned, in that time period we lost about 5 million manufacturing jobs. We shut down almost 45,000 manufacturing facilities. So the impact of energy directly impacted and contributed to job losses.
So as a point of principle, if this bill is about creating transparency for the economic effect of EPA regulations, not about doing away with their ability to promote health benefits, It's fair to say, as a principle, if you increase the cost of energy, there is a direct economic effect upon blue-collar manufacturing jobs, which, by the way, we've also learned increases their prevalence of ill health. Fair statement?
Would agree.
Mr. Siegel, do you agree with Dr. Smith? It seems almost fantastical to me that the more something costs the economy, the more jobs are created. In which case, we should just regulate ourselves. We should just regulate ourselves to prosperity, right? Now, Mr. Waxman said there's no common sense here. I don't see the common sense, and the greater the regulatory burden, the more prosperity we have. Heck, we should regulate our conversation right now, huh? Do away with the First Amendment.
Well, I quite agree. It is kind of a through-the-looking-glass kind of world. The more expensive something is, the cheaper it is for the economy.
Now, you also make a point that there is, if you are creating jobs, oftentimes there is job shift. I think of the vulnerability of these blue-collar workers. You may be losing their blue-collar job while you're creating a job for an EPA bureaucrat. Is that a fair statement?
Maybe an EPA bureaucrat, or it may even be somebody in another country.
Isn't that something that somebody in another country, because as Mr. Ciccio says, it's going to be manufactured someplace, the question is where. All we are about is letting that blue-collar worker who doesn't have a lobbyist, who doesn't have somebody up here with tassels on their shoes, to be able to understand the impact of rules and regulations upon them. I yield back. Thank you.
Gentleman yields back. This time recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Thank you for calling the hearing on the Energy Consumers Act of 2013. Many of the rules in the bill that this bill aims to stop are rules that directly affect both my constituents and companies that employ my constituents. They're rules that I, too, seriously have wondered how they got developed. I'd love to support the bill that would require Department of Energy to have an official consulting role with, similar to OMB, on the drafting of EPA rules where appropriate. For example, I was frustrated to hear that DOE's concerns about grid reliability were not heeded by the EPA or considered during the utility MAC rulemaking. That said, I'm also shocked that this has set precedent that where one department has veto power over another department, particularly an appointee in an agency that's part of the cabinet. I'd like to ask some questions, and frankly, my colleague from Louisiana, we lost chemical jobs over the years simply because our price of natural gas went up to $12.50, $13, and North Sea gas was much cheaper. Thank goodness our economy has changed that, so every plant in my district, I think, is expanding jobs because of our success, at least in Texas, of the low-cost natural gas. So, but now to my questions. Do any of you know whether there's precedent for this type of policy, where there's another agency actually gets to check their work or say yes or no? I want somebody telling us what it's going to cost, and DOE is that agency. But I've never known where one agency could just say, no, you can't do this. Is there any precedent for that? Scott or anyone else? I know we've dealt with these issues for a couple decades.
Well, I'll take a crack at it. I mean, the relationship, and I know, I think Professor Steinzer also has some stuff in her testimony on this, but the relationship between the Office of Information and Regulatory Affairs at OMB as kind of a regulatory traffic cop is a similar relationship.
But even they only check what, for example, in this case, EPA or some other agency does.
Right.
They don't, and theirs is fairly limited. I would be more interested in forcing agency cooperation, looking at the cost and the benefits, and have somebody check the work.
Let me say two things on that. The first is, the DOE really doesn't veto the bill. I mean, Mr. Waxman was saying that DOE would sit around with stroking its mustache and eliminating rules. That's not how this bill works, is my understanding. The DOE performs an analysis. Now, the agency, the EPA that is, could take that analysis and say, okay, we're going to address those energy endpoints. We're going to address those. But the power to address those remains with the EPA. I mean, the DOE just performs the analysis. Now, but I do get the point that you're making. I guess I would say maybe there is, I've heard a couple of things in discussion back and forth today, which sounds like there could be areas of common ground on legislation like this if there were some alterations made or some additional thinking put into it. So, I mean, what I'm hearing is this is a significant issue. These energy endpoints are significant issues. The bill's a great step in the direction of addressing those issues. And so I hope you guys do something.
The bill says, notwithstanding any other provision of law, the administrator of EPA may not promulgate as final an energy-related rule that is estimated to cost more than $1 billion if the Secretary of Energy determines significant adverse effects to the economy. So that language says you may not put the rule out, provided that the Department of Energy has told you not to. And I don't know of any precedent that puts one agency in this kind of charge.
Yeah, and Mr. Siegel's right that we work a lot with OMB, but they really don't do their own. And I'd like to have somebody in the place of doing an economic analysis. That frankly, the EPA, that's not their job. Our laws have said EPA looks at the environmental impact and how they can, but I also want somebody to say, okay, let's see how we can afford it, other than going to the courthouse, what ends up being very expensive for both the government and the litigants. Dr. Smith, in your testimony, you testified the EPA should employ a cumulative impact study when preparing these rules. Do other agencies and departments utilize this type of study in your rulemaking? And if they do, how often does it compare to EPA?
Well, there aren't too many other agencies that have done analyses that compare to EPA's, but EPA itself has done these kinds of comprehensive analyses. They've done them in the past. They have tools that are ready to go, and the only question is why they haven't been using them. My feeling is that because there's no requirement to consider the costs whatsoever under the Clean Air Act, that defies common sense too, that we're imposing our entire Clean Air Act without any consideration of costs. And that has led to the kind of inappropriate and non-credible, quote, economic estimates that are coming out of the agency at this time, when they fully well could do full employment, full economy analyses of their own.
Gentleman's time has expired.
5 minutes goes by so fast, Mr. Chairman.
This time I recognize the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. I've got a series of questions for several of you, but if I could start with Ms. Steinzer. You open your remarks with some pretty scathing challenges against some of the oil energy producers by going over their profit margin, their profits that they make. I think you had talked about maybe, according to your testimony, $119 billion in profits. Is that correct?
Yes.
Okay. What level would be appropriate?
What level of profits?
Yeah, if they're making around 15% profit, you're coming at this a pretty strong view. Should they only be making 5%?
Well, if I were in charge, they would be giving a much larger share of those profits to the same blue-collar workers that people have expressed so much concern about.
So, in other words, okay, so it has nothing to do with energy or for health. It's just you say they shouldn't have this money. So, am I correct?
No.
I don't want to dwell on a lot because I know that this money goes into pension funds and retirement accounts for people. So there is some value to having a corporate make some money. I'm just curious why.
And I'm not saying corporations should not make money. I'm saying that these are some of the most enriched companies in the country that are up here.
Okay, well, and ConocoPhillips is an example. They make 15% profit. Okay, I don't know that that's exorbitant, given such a diversity that they're in, from chemical manufacturing to oil production and energy production. I'm just curious. So you seem to be willing to attack the profit margins of these companies, and thereby, okay, that's fine. I've run into people like you every once in a while. But let's go to Dr. Rahm. You made a very poignant issue earlier when you were talking about the individual that was standing there next to it for 5 minutes. Was he your patient or someone like that?
I didn't see him in the emergency room, but I saw
Okay, he
him.
wasn't your patient?
Yes.
Oh, he
for
was
a period of time.
Well,
yeah.
Did you have any children that ever? I don't want to make a big deal of it, but did you have any children that ever went outside without a coat on and they were sick? They got sick from being outside, or? I'm just curious. Did this person have a level of personal accountability? If he had a pulmonary problem and stood there in front of an exhaust pipe for 5 minutes that you referred to, didn't he have a person just to step back? Did you ever tell him that? Or did you say, let's blame the government or let's blame that bus for running there?
Well, he was intubated at that point, so I couldn't ask him that specific question.
I think it was a very good point to raise, and I think it is
the
important.
thing.
And I'm with you on that. I think you made a good point, but I also think there's a question about it. So, but I want to go in more on what you were talking about.
I agree with you on personal responsibility. I mean,
So now
we give people
and
medicine.
you and others have testified time and time again here before us about asthma and other health-related issues. But can you help me, doctor? How do you differentiate someone getting asthma or some kind of airborne disease from being outdoors from when they're indoors? If they spend 90% of their time indoors, why do we always keep attacking our outdoor air quality when that only represents about 10% of the time of the air we're exposed to? Do you think we should be looking at indoor air quality?
Oh, absolutely.
What do we? But that's not where the EPA doesn't have any authority to do that. And I'm not sure I want to get them in my house. But can you differentiate when someone comes down with an asthma attack? Or can you differentiate? You can tell me they get that because they were riding in their car outdoors, or when they were inside their house on a couch that was giving off formaldehyde.
Those are very good points, Congressman. Indoor air pollution is a real problem. The WHO this week said there are 3.5 million deaths from indoor air pollution and 3.3 million from outdoor air pollution, so they're almost equal across the globe. In this country, when
But
we're
the EPA
indoors,
says the indoor air quality might be as bad as 100 times worse than indoor, and on any given day, 5 times worse.
Yeah. Indoors.
How do you differentiate it?
Yes.
Why
indoors,
do we keep attacking one group and not the other?
Indoors with a room like this where we have central air conditioning, the ozone is virtually zero. So we tell our patients to stay indoors on bad ozone days. But the PM and the sulfur oxides and NOx get indoors as well as outdoors. So we have problems with the other pollutants.
Okay, I think we've run out of time. If you could get me some other information about how you differentiate it, would be very helpful.
Gentleman's time's expired. At this time, recognize the gentleman from Kansas, Mr. Pompeo, for 5 minutes.
Thank you, Mr. Chairman. You know, I'm puzzled how this discussion evolves. We have a piece of legislation here proposed by Dr. Cassidy that is about information. It's about disclosure. It's about policymakers having knowledge about what a particular federal action, whether that be a statute or in this case regulatory, what costs it would impose. And I want to go down the entire panel, and this is just a simple yes or no question in the fine tradition of Mr. Dingell. Yes or no? Do you think federal policymakers, regulators, ought to know and communicate to your constituents, Mr. Sissa, your patients, Mr. Rahm, the cost of a regulation?
Yes.
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 Yes. Yes.
Yes.
Great. We have consensus. Let's mark the time. You know, that's what this legislation is about. This is about identifying costs. I assume everyone would also think that and know the benefits of a regulation as well. Everyone's nodding their head, so we have consensus there as well. I mean, we start here, and we have a member talking about climate change and the fact that last year's temperatures are proof of climate change. I mean, it's just you can't let these facts go in. I mean, these intensely unscientific statements go unchallenged. Mr. Siegel, we end up talking about these health benefits. You'd mentioned this, and if you could just give me 30 more seconds. Blackouts, brownouts, electric reliability risk, and its relation to the thoracic health of Dr. Rahm's patients.
Well, sure. There are several different ways in which it's related, but directly, the cost of electricity is a major cost factor for hospitals. So if you increase electricity costs, you increase the cost of providing medical care at the hospital. And in fact, what we call electronic medicine these days is heavily dependent on affordable and reliable power. But then, in an indirect sense, I think we've all established, or at least many of us have agreed, on the notion that high electricity prices make industry less competitive, make gasoline more expensive, and as a result have a negative impact on employment. Employment is a great research done by Dr. Harvey Brenner at Johns Hopkins estimates the amount of a percentage increase in unemployment to the amount of actual increase in mortality and morbidity. And that's not taken into account, frankly, in EPA's benefits analysis. See, that's an indirect cost, and they don't take that into account. So they'll cook the books in the other direction, but they won't take into account these macroeconomic impacts on health.
Yeah, I'm actually, I'm certainly worried about cooked books, but I'm even more worried that there's no analysis being done, that they're simply not even opening the books or attempting to prepare the books or even considering cost. One last point of cleanup. Dr. Rahm, you made the statement about ozone at 75 parts per million, said it saved certain lives if we went to 70. Is that right? Did I have the data right?
At 75, it's between 1,500 and 2,000 lives that you will save if you are meeting that standard. We're currently above the standard.
Got it. More lives if we went to 70?
4,000 at 70, and that was...
How about at 60? More lives at 60?
Double.
Awesome. How about 0? More lives still?
Background's probably in the 30 to 40
There
range.
you go. We get perfection. Background, 35. More lives still saved? If we get from enforcing 75 to 70 and then we ultimately get to 35, more lives saved, I assume.
When you're at background, you're at background, so I can't really say.
But it's better than 70. You'd rather be at background than at 70.
Yes.
Yeah. I just, when I hear folks say that, sometimes folks who think this kind of legislation makes sense exaggerate too. I think it is silly to make statements about perfection and background. I think they're not even worth talking about. I mean, it's silly. And so I think we all have an obligation to be straightforward about what's possible and the real costs associated with those things without saying, hey, we're going to kill people if we don't go do this. I think it's disingenuous. I think it doesn't serve the public interest very well, and I just hope we'll all refrain from that. I yield back.
Gentleman yields back. This time recognize the gentleman from Illinois, Mr. Shimkus, for 5 minutes.
Thank you, Mr. Chairman. And I'm going to be quick because I know the bells have rung, and there's probably a couple of members that want to also ask questions. I do appreciate the panel. Listen, we're legislators. The way a bill becomes a law is there's an idea. Mr. Cassidy has one. And we debate it, we move it, and it becomes law. And it changes the dynamics. And that we'll hold both sides. And to disparage colleagues who are bringing legislation in good faith is just unfortunate because it just frustrates me that we don't have to stoop to that. And Dr. Rahm, I applaud the profession. I love people in the healthcare sector. They're servants. They do great work. But I also am concerned about a mayor who can try to ban the big gulp, doesn't have clean air emission buses like natural gas or biodiesel transport systems that would help alleviate some of that issue. That would not be an issue if it was a natural gas bus. So I'm sure there's some there, but and then I'll just end on this, and this is the question. News Source Review is a public policy by this country that says that if we're going to retrofit manufactured facilities or power plants with new generators, more efficient, maybe it doubles the efficiency, then the power plant has to go through a whole new permitting aspect on their environmental regs. So I just asked this question. If we know that these generators can double the efficiency and the power plant is meeting current air standards, and so you're going to get more electricity output, almost lowering the price in half, does it make sense to, if it's meeting the current environmental standards, does it make sense to force the industry to reapply for all the air permits? And we'll just go left to right, and then I'll be done, and then we can move time to other.
No, it doesn't. And that's why this legislation is needed, to identify what the costs are, so that if the costs are high, then hopefully it'll give the EPA an option to go back and look at alternative, less costly options. And along with this question you asked, I'd like to address Congressman Green's point. If there isn't a precedence, there needs to be a precedence, because the EPA is not an agency with expertise in the energy area. In the area that the rules that the EPA is dealing with is so energy intensive related that they need help from the Department of Energy to make sure that they get it right.
I would agree with Mr. Ciccio and your statement, and it really points to the fact that oftentimes EPA in particular looks at these things in silos and gets to some of the regulatory conflicts I talked about in my written testimony. An example, I mentioned Tier 3 earlier. We have a regulation that requires us to take more sulfur out of gasoline, even though we've reduced it 90%. That's going to increase GHG emissions 1 to 2%. And then we also have EPA's GHG regulations under the PSD provisions and facing NSPS GHG relations at some point in time in the future. EPA's announced that. So it highlights your point exactly.
Yeah, I would point out that for transparency, EPA generally is willing to listen to a power plant company or manager to discuss multi-pollutant controls and NSR.
And not to cut you off, this is current rules and current laws that we apply by now that they're not. Obviously, they force people then to go through the old permitting process if they're going to bring a new generator online. It's just the current law, and it's crazy. It makes no sense, but that's current. Ma'am? No comment?
I think it makes perfect sense.
Okay, that's fine. Dr. Smith?
It serves as a hindrance towards efficiency improvements.
For once, my law degree maybe trumps an MD. This is a legal program, and it gets the incentives exactly backwards, Mr. Shimkus. It prevents efficiency improvements. It even prevents pollution prevention, even though that's supposed to be an explicit exception.
Exactly. Thank you. I yield back.
This time I recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Time is limited, so I'll have to be brief. I agree the whole idea of this bill is so that the EPA can take a look at it and say, okay, maybe we need to find a less costly way of doing this if it's a good thing to do. But more importantly, I think we ought to be looking at those estimates, knowing that the EPA consistently, in just the short time that I've been here, the last 2.25 years, I haven't seen the thing yet. I think the EPA's gotten the numbers right on. We may disagree on policy, but at least like to have the numbers be close to reality. They're not there, which is why I think is part of the reason that we have this bill, have somebody besides the EPA taking a look at these issues. I, for one, believe that responsibility rests here in Congress. When it comes to the arguments that people say there's no precedence for this, or there's no precedence for the act under which we're talking, there was no precedence for the Clean Air Act in the first place. So under that argument, we should never have had this bill in the first place. And I would have to direct that to my friend, the law professor, because as you know, this country is about starting things and doing things a different way than the rest of the world. Otherwise, we wouldn't have a democratic republic form of government, because we were the first ones in the world to have that with the nature, recognizing the city-state of Athens and some other minor experiments in that. But from a nation of this size, we were the first to have a democratic republican form of government. I think it's a great way to go, and I think we should go there. But I'll tell you one of the problems that I see from this testimony today and from the questions that I hear is that we actually had a member here say today something about this would hinder everyday decisions. $1 billion in Washington is considered an everyday decision. Well, before I was here, I came from the Virginia legislature, and the last year I was in the Virginia legislature, we spent our entire budget was less than $40 billion. To me, $1 billion decision is not an everyday decision, and that's the reason we need this bill. I don't understand these folks who don't want to have Congress getting more information and have us taking more responsibility. You know, the people elected us to be responsible for these things, and coming up with a new bill, a new idea to put checks and balances into the system, not to say we don't do something that's good, but to put checks and balances there at the $1 billion level. When that's unreasonable, it's clear we have a problem in Washington, and I think this bill will help fix that.
Gentleman's time yields back. This time recognize Mr. Olson for 5 minutes. We have 6 minutes left on the floor for a vote.
I thank the chair and welcome to the witnesses. I know we're running short on time, but Texans can always find time to brag about the Lone Star State. So I'd like to remind my colleagues that my state was the fastest growing state in the Union the last 10 years. People from all over the country were flocking to Texas for 4 reasons. Our income tax, 0. Common sense regulations, right to work state, and cheap, reliable energy. One of the biggest challenges my state faces in the future is reliable energy. ERCOT, who controls power generation for about 90% of my state, has said we need 5 more power plants, large ones, coming online by 2014, or we risk having another power crisis. If we have a summer heat wave, like in August of 2011, we'll have rolling brownouts and blackouts again. EPA's war on coal has stopped 2 new power plants from being built, Las Brisas and White Stallion, along the Gulf Coast there by Corpus Christi and Bay City. My question is for you, Mr. Siegel. Can you talk about the reliability issues you see coming? Are my home state's challenges the exception or the rule?
No, sir. They're not the exception, although Texas faces a particularly onerous situation, particularly with the amount of manufacturing assets we have in refining and in chemicals, et cetera, that the entire rest of the country relies upon for their manufacturing. Look, prior to those rules being laid down by the EPA, our friends over on the Senate side spent 7 months trying to figure out if EPA had even talked to FERC about the electric reliability impact. I'd like to read their conclusion. Instead of taking the questions and concerns seriously, the EPA largely ignored requests for the agency to work closely with FERC and reliability experts to identify potential reliability risks and then amend the rules to lessen those risks, very similar to what your bill would do. Indeed, in recently released internal emails, FERC employees expressed frustration with trying to work with EPA, noting, quote, "I don't think there's any value in continuing to engage EPA on these issues." They had no interest in trying to address reliability on an a priori basis.
And that makes my state's crisis acute. Mr. Williams, Mr. Ciccio, like to add anything to Mr. Siegel's comments?
I'm glad you brought this up. I've worked in the manufacturing sector for 42 years, my entire life. And I can confidently say that there's greater concern about electric reliability by manufacturers than ever before, and it's because of the EPA rules on the power sector. And it's a prime example of the EPA not having the expertise to deal with the entire direct and indirect implications of their actions.
I would agree with Mr. Ciccio and note that, as I mentioned earlier, refiners, other than crude oil costs, electricity is their second largest cost. The same applies for petrochemical manufacturers. And reliability issues will be significant if there are reliability issues. They're going to significantly impact our sector and our ability to make the products that make this country run.
One question for you, Mr. Williams. How would this bill have helped if it had been law when EPA got in and destroyed our flexible permitting system? Remember, they came in, rolled in 17 years of precedents, overriding the Clinton administration, the Bush administration, the first years of the Obama administration, threw it out in the court. The Fifth Circuit finally had to overrule it. But how would this bill have helped that situation, and what's the damage been done? Have we recovered yet?
Well, the flex permit issue is a great issue because EPA officials had told people in our industry, yeah, it worked, you just didn't do it the way we wanted you to do it. So it was, which required folks to go back to the drawing board and deflex a lot of their facilities. And it goes back to the point I made about how this bill would help. This bill actually, as many members have highlighted today, add more transparency to the process. It will require, it will allow the Department of Energy to take an energy impact and economy-wide look at how all these different regulations fit together and how the benefits and the costs are assessed, in some cases how the costs aren't assessed. I mentioned the conflicting regulations with Tier 3 and greenhouse gas before. There's been a lot of talk about PM. The Tier 3 rule also talks about addressing PM. EPA, as was earlier mentioned, just finalized a PM standard that they say was protective of the public health and environment. The PM analysis in Tier 3 did not look at that. It looks at it in silos. So how do we know where the PM benefit is actually coming from? So these are just examples of oftentimes the fact that these regulations happen in a silo and there are implications that aren't considered when EPA is going through their analysis. This bill would help because the Department of Energy would certainly prevent against the fox guard in the hen house scenario, for lack of a better analogy.
Thank you. See, my time is going up instead of going down, so I yield back.
Gentleman's time has expired.
Mr. Chairman?
Yes.
Mr. Chairman, I ask for unanimous consent to submit a letter for the record from the Natural Resource Defense Council addressing its concern with the Energy Consumers Relief Act.
Without objection, so ordered. I'd also like to enter in the record this press release from the side of environmental journalists. Also, I want to correct, I made a statement that the U.S. was the #1 oil producer in the world. Actually, we're the #1 natural gas producer in the world. We're third in oil, and they anticipate we may be #1 in 2018. So I want to correct that. Also, I just want to clear up briefly, as a result of our last hearing, Mr. Rush, it was your understanding that I had agreed to a hearing on climate change, which, if I led you to believe that, I think I was mistaken. However, having said that, I personally have talked to our staff. While we have different priorities, many on your side view climate change as the most important issue. We believe jobs, the economy, and some other things are more important, but our staffs will be working together to try to develop a format to move forward to address some of your concerns on this issue.
Well, thank you, Mr. Chairman. I guess I kind of don't know where we're at because I was assured, I thought that we had a hearing schedule, a definite hearing schedule, but as long as we are proceeding in that direction, I guess we have to go along with it. But, Mr. Chairman, I don't think that we have to decide between climate change and jobs. I think that's not the issue here. The issue is whether or not we're going to have scientists and climatologists before this committee to offer expert opinion. Thank you.
Thank you. Thank you. The record will remain open for 10 days, and I want to thank you for your time. We appreciate your testimony and expertise, and with that, this hearing is adjourned. Thank you.